Well, thank you, John, for picking this venue. Thank everybody else for being here on a gorgeous day. How many are people who have gone to law school before? Okay, about half. How many are geeks who haven't been to law school? Okay. What we're going to look at today is from a learning sciences perspective. The learning sciences, we'll talk a little bit about it. But it basically looks at how people learn. Okay? And so it's outside of the context of just how people teach, but how people learn also. So we're going to look at that. And from both a law school perspective and a general perspective, what is the learning sciences first? Well, learning sciences explores the relationship between the design of a learning environment. So for instance, some of you will learn very well in here through a lecture. Some of you won't. Some of you will be bored. Some of you learn better, through the internet. Some of you learn better reading books. Some of you learn better with music playing. Okay? So learning sciences looks at the different modalities that people learn through, and basically how you can get information into your noggin and be able to get it back out. Okay? And it leverages different cognitive theories and different cognitive theories such as cognitivism, constructivism, adult learning theory, and we'll get into that a little bit later on. But basically the whole idea of it is that each individual is different. Okay? So if you look at learning from a scientific standpoint, how can learning be enhanced for each individual, right? And that entails changing the learning environment for most law schools, and we'll find out about that in a second here. What's the case dialogue method? Well, it's a combination. This is what the Carnegie report calls it now. It started, some people call it the casebook method, right? And for those of you who have been to law school, you know what a casebook is, all right? It's about 800 pages of dense information, and you're supposed to cull the information out of that thing, which is, on average, I would say personally, about 10 to 20 pages worth of material that you have to cull out of it. And you don't know what 10 or 20 pages that is, all right? You have no idea, especially when you're first starting out and you're in first year law, right? So it's a very, very confusing, cumbersome book that you rely upon for your classes. Now, the dialogue aspect of it here comes into looking at when you're actually teaching the class. We'll pick out one person in the class. Typically, you'll pick out one person in this class, all right? And you don't know who it's going to be at the start of class, all right? And then what's going to happen is the professor will have, so to speak, a dialogue, a Socratic dialogue with that one individual person, while the rest of you are supposed to listen in and garner and elicit and kind of active listen to the dialogue between the two, and thereby learn certain aspects of the law through that dialogue between the two people. Now, the question is whether or not that happens, whether or not there's a learning that occurs, number one, between the dyad, between the professor and the student, and number two, whether that or not the vicarious type of learning between the rest of the classroom actually is efficient. All right? Now, class structure. The first year class is going to have twice as many people as this, sometimes 3 times as many people as this, right? 100 or more students, almost by definition, limited access to the professor. They have class hours, or they have office hours, but there's so little first year class interaction with the professor. Very little time to elicit responses from the professor based on your questioning, right? Very little instruction in the doctrine that you need to know, because most of it, again, is going to be based on the cases that you've read the night before. 2 or 3 cases, commonly 30, 40 pages. All right? So basically, you're talking about a basketball game that you've seen written about from 1970. In another game you've seen written about that 40 pages about a basketball game from the 60s. Another 40 pages from the 80s, right? And you know nothing about basketball. So what is the salient point? But you have no idea. 1 or 2 sentences per of those cases, right? But what is it? Is it about rebounding? Is it about shooting? Is it about defense? Right? So you're totally confused. You have a lot of reading. You have a lot of unimportant facts in your head. But what do you do with all of it? Right? What do you do with all of it? And what happens? Well, you're supposed to learn through analogy. You're supposed to say, I see this here. And I see the point being made. And they're saying that if you have a good rebounding team, you can win. And what makes a good rebounding team, right? You have Dennis Rodman. That makes a good rebounding team, right? If you're from the 60s, you have Bill Russell. That makes a good rebounding team. But they don't point it out to you, all right? In fact, they'll do just the opposite in class. They'll say, well, Bill Russell was a team captain. He wasn't really a rebounder, now was he? Right? And so they'll lead you off track, and you're supposed to still remain on track, but you don't. Most students don't. I didn't. I hated it. Now, Carnegie report, what is the Carnegie report? It's a report that came out a year or two back, and it delineated, it studied about 16 different law schools, right? And basically, one of the things it was looking at is what I'm saying really true. Is this still prevalent? Can people still be teaching the way they were in the 1870s? Which essentially the Casebook Socratic Method, sometimes it's called the Langdellian Method. It started at Harvard in the 1880s and then just steadily progressed to all law schools. Essentially, to a large degree, to be ABA accredited, they do look at this to see if you actually use the Socratic Method, the Casebook Method, to see if you can get accredited. So what the Carnegie report basically says that it is used. All right, so we don't have all kinds of different teaching modalities going on in law schools. We have basically a signature pedagogy, which means that a lot of law schools do this. Okay, they call it the case dialogue method. They combine casebook and the Socratic method into one, and they call it the case dialogue method. All right, so it's prevalent. Not used in it, essentially, they call it second year is 2L, third year is 3L. Not so much in 2L and 3L, but for your introduction in 1L, it's very much used at a lot of law schools still. So, remarkably uniform. That means the curriculum, too, is remarkably uniform. So, for instance, you'll get torts, con law, civil procedure, right, criminal procedure, contract law, and a couple other ones thrown in there for good, real property. And so the kind of learning that you have, the case books, everything that you use in first year, the types of professors, the types of way that they teach is remarkable, like they say, remarkably uniform throughout, all the ABA accredited schools. All right? So this gives us a good jumping off point at this point to say, okay, what is this uniformity? And does this uniformity work? You see? Because what you're looking at this point is that if 180 law schools use it, almost, right? Some of the more liberal ones don't use it near as much. Then it must be worthwhile. Students must learn, right? Else, why would they use it? It seems counterproductive to simply continue a convention from Christopher Columbus Langdell unless it worked, right? And there are those of us who think that it doesn't really work, that it's a convention, that it's used by the ABA as a way to accredit schools and to give a patina of a sense that it's actually being taught. Law's actually being taught, students are actually learning, but who says that it is? And in fact, I went to a conference in Chicago in October, and the whole idea of the conference was students are not learning. It's an ABA-sponsored conference. Students aren't learning. They don't know the doctrine, they don't know how to write about it or talk about it. And this, now from a learning sciences perspective, is it's a really awesome study. This is back in like '92 that Susan Williams did this. And basically she looked at legal education back in that era. And most of what you will find through legal education is people getting up and talking about it with no real research data, right? And you find a lot of polemic kind of discussions and people saying, oh, it works because I think it works. It works because the students listen. It works because, I don't know, because everybody does it. So it works, right? And that's what she found. And then she went and she did more of a study here through the learning sciences there at Vanderbilt. And she looked at how the students are actually taught, right? And she found students don't have an overview of the doctrine before they're discussing it. So for instance, they don't know what basketball is before we're talking about rebound. They just jump into a new area of law, right? What is a rebound? I don't know. I have no idea because I don't know what a basketball is, right? Sink or swim. And that's what I think a lot of us encountered at law school. Either you do it and you grudge through it and you pretend like you like it and you pretend like there's a reason for it, or you don't. You sink and you drop out, right? And a lot of times students, and this is a good reason, this is one of the reasons I'm giving this talk today, is because there's a necessity for college, right? This is part of the reason I'm talking about this. I'm sure that some of the geeks would think, well, why do we even need college? If legal instruction is so awesome, right? You got Socratic classroom, and you got all this great stuff going on, and you got these noted professors, and you got all these kids so interested. Why do you have to have college? What's the use of it? It's superfluous. They're learning in the classroom, aren't they? Well, there's those of us who would argue that they're afraid. in the classroom. That the only learning that occurs is on eBay. While when they're not picked on, this happens a lot too, a lot of discussion about it. If you're not the one who gets picked in your traditional Socratic classroom, there's a big sigh. I didn't get picked on, good. And then you open up your computer and you start searching eBay and you learn things that way, right? Like what you're going to buy today. Because you're not the one who's being harassed, is what a lot of people would say. Is the one student that has that supposedly Socratic dialogue, right? Between somebody who's leading them in directions, they don't know where they're going, all right? So now let's say that it did work. Let's just say, for instance, the analogical model does work. That is what Langdell used. If you have a number of cases and all of a sudden you can ferret out, so for instance, you can ferret out all the different angles and things because you know, you've watched so many basketball games that you understand, you can see what rebounding is and you can discern what's good rebounding and what's not by the dialogue that goes in class, right? Well, number one, you might be wrong and there's nobody to tell you that you are. All right? So even if you can induce and analogically infer what's really supposed to be inferred from these particular cases on any particular day, you might be wrong. And there's nobody to tell you you're off base. And so you're going to continue down the incorrect avenue, possibly to a dead end, but you don't know it's a cul-de-sac. All right? You think you know what's going on. Number two, those of you who are well-versed in football or basketball or soccer or lacrosse or whatever, you've watched thousands of games. So your inferences are likely very well to be correct if you were to watch a game and you can infer something from that particular game because you have that basis under which to make that, you know, analytical reference. Here, you got 2 or 3 cases from the night before. How are you going to know what a murder or the distinction between first and second degree murder is? Or the distinction between intervening events and proximate cause, foreseeable proximate cause? All these different aspects, how are you going to be able to make a viable inference when all you have is 2 or 3 examples? All right? You may make too many inferences, just the same as incorrect ones. Go down too many avenues at once. All right? And again, you have no checking. See, thing is, after class, you're done. You go out with other students. You go over to Starbucks, like I did this morning, right? And you talk among yourselves, but you have no way to check it with a higher level student unless you seek one out. Right? There is no, I think to those of you who are physics majors, what do you call that when you guys had the thing after class with other students? Where you actually wrote problems and things. You don't do that in law school. All right? You don't have that thing outside of class. It's just in class and that's it. All right? And again, what we talked about earlier is you're supposed to learn through the one student who got picked on today, 1 out of 100 or more. Right? But you're going to be surfing eBay because you're just happy not to be picked. Right? And again, this happens all the time. In fact, at University of Chicago, they make them put lids down. No internet during the class. Which I would suggest is faulty also, saying that the internet is the problem, rather than the teaching, rather than the pedagogy is the problem. If you can't keep people, not entertained, if you can't keep them involved for 45 minutes with something they're vitally interested in, then there's a problem with the pedagogy. Not with the students, you know, searching the internet. So they surf, and then it's difficult to transfer. You can't take this. How are you going to transfer something you learned in the classroom to other places? All right, you can't do it. All right. So those are the problems with analogical reasoning. Okay, what about the casebook method itself? Well, the thing is with the casebook, and again, those of you who went to law school understand this, and those of you who didn't just have to take my. They have to take what I'm saying. It's hard to discern what the heck they're talking about. Right? Murder is what? It's a dead body. You guys all know that, right? A homicide, right? Somebody has to cause the homicide, right? You have to be the causative agent. Okay, that's simple. All right, now you have to act with some kind of a heart that makes that person want to be dead. You want that person dead somehow, either through your inattentiveness or your real super desire to make them dead, or maybe through, you're committing a dangerous felony or something. So you have to have that. All right? Now you're going to look at, well, are they going to be culpable to a high degree, first degree, or second degree? Do they have any defenses? Okay? Do they have any defenses? One of those defenses is self-defense. One of them might be voluntary heat of passion. Okay? Maybe it's involuntary manslaughter, grossly negligent. That's murder. That's a good discussion what I just gave you of murder. Okay? Now, what you're going to do in class is you're going to have 30, 40, 60, 80 pages talking about self-defense. And that's it. You have no idea the context in which things work, you see. What is where is self-defense in a murder issue? How do I discuss it? What does it mean? Does that mean I don't do causation and talk about the person who caused the death? What is a dead body after all? How do you measure whether or not somebody's dead? What if they died 3 weeks after they got hit by a sledgehammer? Is that good enough? You have all these questions and no one to answer them. So basically what we're pointing out here is that the casebook method, as it's used within the classroom, and then students go their way, they go to Starbucks or wherever, it's insufficient. It might be a good start, and it is a convention, so I think a lot of people understand that, right? It's a convention, it's supposed to work, I'll do it. But again, like I was saying, you're going to need something outside the classroom or you're sunk, because you won't understand anything. Unless you're brilliant, and we'll get into that in a second. About, there's certain terms that people use, and they say basically these people are brilliant. They get it, and the other people don't get it, so they don't know what they're doing. Sink or swim approach again. That's what a lot of contemporary legal education is. Now, what are the failures of the casebook method? Okay, very, very, very few people will go into this, by the way. I got a graduate degree in the learning sciences after I got my law degree and after I taught for 4 years, right? Because I wanted to delve into this and not just be my opinion. Oh, I don't like the casebook method because I got called upon and somebody yelled at me. That's my opinion. I think it's therefore transferable to everybody that it's junk, right? No, I mean, from a learning sciences perspective, from a more scientific perspective, really, why is it junk? Where is it junk after all? So this is what I found out, and this is, from different types of research from different, different arenas. Basically what it comes down to is that just like I was talking to you guys, I just gave you guys murder. I gave you a way to describe a murder and to go through it in context and to research it and to talk about it in a full way, right? You got a dead body, you got causation, you got proximate cause, you have malice of forethought, you wanted them dead, or you were just totally irrelevantly, in the ozone when people are around you while you're shooting the shotgun off. That's a way to show that there's malice of forethought, right? And you got degrees, defenses, and then voluntary manslaughter, heat of passion stuff going on. That's easy. Once you get that, it's easy. They don't give that to you. Again, they're going to have 40, 60, 80 pages about self-defense. And you're going to think like self-defense is the most important thing in the world. It's just one part of the aspect, right? Can't talk. You can't talk. You're not part of the dialogue between that one student and the professor, right? That's passive learning, big time. You can't open your mouth, you see. And that's you can't learn that way. You can't. A lot of students will learn actually through teaching other people, through talking and saying, "Oh my gosh, I just talked it out, and I realized I don't know all this stuff, and I realized I do know this stuff." So there's different ways that people learn, and it's not allowed in the classroom. Again, it's a traditional classroom. No alternative ways to conceptualize the material. You got 60, 80, 100 pages from last night, and you got to deal with it. They don't teach you a flow chart. They don't teach you the definition of what self-defense is, by gracious. They don't even do that. What is self-defense? Well, I don't know. What is self-defense? I don't know. It's not in the casebook. All right? Sometimes it is, and that makes it even worse. Because for every doctrine there isn't there might be 2 or 3 that are, and then 2 or 3 that aren't, and then some that are and some that aren't. You're so confused, you can't figure it out. All right? Again, smaller areas of law, self-defense. Okay, how does self-defense figure into a murder issue? I mean, how am I supposed to, do I do it first? What does it do? Is it a full defense? Right? Is it like an insanity defense, which is a partial defense? How does it all fit into the whole context of what we're trying to learn about? And I would argue, students these days are very quick. They're very, very, very quick. They're quick on the internet. They're quick. They tend to be young. They're younger than me, right? And they have fast minds that want to learn. You see? And this doctrine, again, you might discuss one case the entire full hour. And they're just like, come on, tell me the doctrine so I can get on with it, so I can learn more stuff, right? So I can integrate it more. I do this in other classes. I do it in my math class when I was an undergrad. I could learn as fast as I wanted. Here I have to sit there ploddingly and wait for you. So students get very frustrated, right? Very bored. So what does it all end up with? All of this great Socratic casebook method, which everybody says is all this awesome thing because everybody does it, and the ABA recognizes it as a valid way to teach how to think like an attorney. What does it end up with? From a learning sciences perspective, what does it end up with? aimlessness, inconclusiveness, confusion, right? Game playing. Questions to this point? Especially from those of you who haven't been to law school. Yeah.
Well, I haven't been to law school, but I've been around them for a while.
Yeah.
So kind of what you're arguing is that the Socratic method is very selective. You have implied that an Aristotelian method might be more appropriate because there's a broad set of doctrines that could be kind of applied globally to the matter being taught. What I will, and that's just an assertion from what I heard you say, but the question here is, what I hear from our faculty is that, as you said at the end, we need to teach them to think like attorneys, which is
Professor Kingsfield, yes.
Which is not the hard and fast doctrine. It's the stuff at the edges where these doctrines kind of mesh oddly.
Yeah.
And that's what our faculty end up talking about in conferences are these messy bits. And so for them, it is what legal thinking is, rather than the very clearly doctrinally defined.
Yeah, and from a learning sciences perspective, you can't think at the edges if you can't think at the center. Okay? And that's what everybody talks about. They put the proverbial cart in front of a horse. So you can talk about the edges. You can talk about, again, metaphorically, what makes a good rebounding team. Not a good rebounder. Notice how now it's a team, right? And go back and through history and figure out what that is. Is it the coach? Is it the players? Is it what? But unless you know what rebounding is, unless you know it, then you can't describe it. Unless you have many examples about it, then you can't get to the edges, you see? And basically what I researched there at Northwestern Learning Sciences program is what makes the distinction between an expert and a novice. That's really what I studied, all right? So how do you take a person who's a novice in any area, specifically I looked at law, right? And how do you get them to be an expert, okay? So it's all great and good to talk about thinking at the edges and being brilliant. But how do you get to the place where you can think brilliantly, you see? And that takes a knowledge base. So for instance, they have studies with chess experts, all right? So you have, I think there's 60, those of you who play chess, isn't there 64 places on the board, right? If you take the board, okay? If you take the board with chess experts and novices, people who know nothing about chess, and you put it in a random order, give them 5 seconds to look at the board, right? And then replicate that board. Novices and experts will do exactly the same. No difference at all. And you'd think the expert would be able to remember the entire board. Now, you do the exact same experiment and put it in a cognizable order. So for instance, a certain gambit or something, right? You can give the same 5 seconds. The novices will be just as confused as before, and the experts will know it. They'll remember it forever. You see? Because they understand the doctrine of chess. They understand why those places are there, or why those board pieces are in a certain position. And they can remember it, and now they can work at the edges. So
that's case method. That all of these stratagems are based on prior experts who have done these. They've written them all down. And what you do to become an expert chess player is you go through and memorize all
exactly.
Those.
Yeah. Exactly.
But isn't that still casebook?
No.
Why not?
No. So what is a casebook?
Well, you've got the written material, you read through it, you synthesize it, and it comes back out. So when you're playing the game, if you're going to play a King's Gambit, the first 20 moves are scripted.
Right. But you know the moves.
Yeah.
And through the casebook, you don't. You don't learn the moves. You don't know what the moves are. You know what a move is. And that's the whole problem. As well as part of the problem.
You just start at the end, at the gambit.
Now, so a lot of people will simply say, well, we have these great law students here. And the rest of them, so what? 10 of them are good, really awesome, and another 90%, they just don't get it. And so what they do is they talk about them as they have a tacit understanding. They know something in a way that other students don't. So we're just going to say it's a mystical thing. We're going to say, you know what, great. They know it, the other students don't. We taught them, right? We showed up. We got in front of the class and we presented the casebook and we did the Socratic Casebook Method during class and we put in our time, and if they don't get it, it's not up to us anymore, right? So they say it's a tacit understanding. This is how they talk about it. It's a tacit understanding, which means what? They have special vision. that mysteriously inculcate the information into their noggin, right? These people have gifts. These people have, you know, they have this inherent, mysterious, intuitive skill that other of us, you know, and all as professors, we have it. But, you know, there's other 80–90% of students who everybody worries about these days because it's getting more egalitarian and people actually care about the rest of it. They just don't have it. What are we supposed to do? We're not going to do anything about it, really. We're just going to say if you don't have the mysterious, unwritten, inherent, tacit understanding of all this stuff we did in the classroom, and you can't intuit what you're supposed to write on a piece of paper at the end of the semester, what good are you? We're not going to bother with it. But now Learning Sciences doesn't look at it that way. Learning Sciences looks at it from this perspective, more towards a mastery learning perspective. Some fella in Jersey, I forget if it was Seton Hall or wherever in the 80s, he said, wait a minute. Two guys, actually. You know, we're going to take this classroom and we're going to make everybody an expert. And what we're going to do is we're going to need some TAs. We're going to need some extra time. We're going to need to change around the classroom. Right? We're going to need to change it around. We're going to need to give them the doctrine, like I was saying. Right? We're not going to have them cull it out of 800 pages of amorphous glob. We're going to give it to them. Self-defense is what? This is self-defense. Here are the different examples of self-defense. This is how you can look at self-defense from different angles, right? You know, was there a need for force number 1? Was there excessive force used number 2? And then you go on. Was it an initial aggressor or whatever? So we're going to give them that stuff right up front. Forget about the casebook. You've already had the casebook in the classroom. You've already done it. We're going to give you more so that you understand this stuff. Because now the onus is on the professor here to teach. And mastery learning says 80% of the people should pass easy. Not 20 or 50%, right? So what's part of this? It's looking at the adult learner as an adult learner. Right? Not as a kid. When we were kids, what happened? We got lectured at and we took tests and we had smart kids in the front of the class and the dumb kids in the back. Right? And we were all either in the front, middle, or back, depending on the class. Right? And that's just the way it was. That's it. That's it. This looks differently. An adult learner is different. We're not kids anymore. Adult learners want to know what they want to know. They want to know why it's useful. They want to know where we're going with it. And they want to know how to use it. They want to actually use it. We were talking about chess. Right? You don't play the game of writing about law when you're in law school, in the first year especially. You go to class and that's it. You don't actually write. Typically you get a written essay exam at the end of the semester. You had no practice writing that thing. Right? You had no practice playing the chess games, the hundreds of chess games like we're talking about. Right? So they look at that, the Learning Sciences does. So one way to look at it is, okay, instead of this analogical reasoning process, which is supposed to magically occur, let's look at other ways that people learn. Like I said, some people like to just sit and learn. I like that. Give me a book, give me the information I need, and I can learn. You know, that's basically cognitivism. Flowcharts, diagrams. Diagram out self-defense and murder, and let me see it on a board. Let me understand the concept, not from a casebook, because it doesn't give me that. It doesn't give that type of learning credence, you see. All right? Let me repeat it. Some of us are dense. We got thick skulls, right? Let me repeat it a couple of times. You go from one case to the next day, next subject, next. You don't know what you're doing. You have no idea. You get to the end of the semester, what was all that? Ability to repeat the class. Let me hear the class again. And again, we come, John, into college. Click, play again. That podcast. Let me hear it again. Let me hear it again and again. I'm extra dense today. Let me hear it again. Let me see it. Let me see a graphical representation of what I just heard on the podcast, so I can follow along. And so I'm getting, auditory, different modalities, right? Constructivism. This is pretty interesting. Constructivism. How do people learn through constructivism? Take your own learning experiences already and add to them. And again, this goes to each individual person has certain ways that they have conceptualized information in their minds, either through pictures, words, graphs, right? And so present the material to them consistent with the way they learn. You're still going to have to write about the same stuff at the end of the semester. You're still going to have to write about murder. But now that material is going to be represented in your mind, not through some amorphous class discussion which you didn't understand. It's now going to be represented in a manner consistent with your learning style, so that you'll be able now to be able to talk about it in a consistent way, right? Revisit it. And again, designed to engage the learner, all right? If you're a teacher and you're teaching material that you know about, and students are on the internet, or students are on their computers, there is no reason why they should be induced to surf. No reason whatsoever. And again, this goes to the teaching. You know, another thing, the ABA requirements for professors are what? If we're going to hire a teacher, what are they looking at? Who knows? They're going to hire a new law professor. Scholarship, which means what? Law review articles. Which means what? Revenue, which means what? Higher place on U.S. News. That's why they hire. They don't hire because people teach. They don't hire because they have enthusiasm. They don't hire because they have an ability to relate to people. That's not number one. That's way down the list, 5 or 6 maybe. Next thing they look at is where are they from, where they graduated from law school. That's number 2. So did you publish? Number 2 is that. Number 3, are you going to want to continue publishing? Which means continue writing, which means 90% of what you're going to do as a law professor is write and go to symposia and things like that. And this is what the ABA requires. So this is what they do, all right? So you get professors who may be awesome teachers, but if 90% of their tenure, and let's say it takes them 7 years to get 10, if 90% of what they're going to be graded on in tenure is how many articles they published and in what journals they published in, they're not going to care about teaching. They don't care if people surf the internet. They don't care about an engaging class. They shouldn't, because that's not going to put, you know, bread on their table in 7 years when they do or don't get tenure. Yeah.
And that's criticism may or may not be valid.
Depends on the person.
Certainly not limited to law schools. That's true in the entire university environment.
You bet. And law schools are no different, right? Law schools are no different. So where does that leave the student who has to learn this incredibly dense material, complicated material, right? Where does that leave them? It leaves them confused. So what can you do? Well, you can take a law text and you can reformulate it, right? And just like what we were talking about, what is a King's Gambit? Show it to me on one piece of paper. I don't want a 40-minute class about King's Gambit with 2 or 3 cases and stuff, so I don't even know what a King's Gambit is. Show it to me. Teach it to me, right? I want to read a book with 3 pages, well, just 3 pages what a King's Gambit is. Now I want to know what a King's Gambit is in 20 pages. I don't want any case law about it. I want to know now I want to practice it. You see, I want to play the game with it. You don't get all that chance, but one way you can start with law text, get rid of the casebook or augment it. Augment the casebook, okay? You're going to continue with the casebook, augment it, and give a smaller book, which calls out, like what I said at the beginning, that 20 pages of real information that you need out of that 800-page book, all right? Give me that 20 pages so I can now understand it. And if I'm a cognitivist learner, I can repeat it, and I can read that 20 pages again and again and again. Yeah?
When you've been using the word casebook, have you had in your head a model of, say, the old Fuller and Eisenberg, which had just case, or casebooks? There are a lot of books now that incorporate extensive notes that are more than just bare.
Combination of both is what I'm saying. Yeah. Combo of both. Now, one thing I talked about briefly earlier, New York Law School, Joanne Ingram, she looked at the various ways that people learn, right? Law students. So what do you mean learning style? The way that you conceptualize that information so that you can understand it. Okay, what she found was that, you know, the case dialogue, there's a lot of talking, right? There's a lot of talking going on. So maybe 25% of people are going to benefit from that. Not everybody does not benefit from the casebook dialogue. Some people do. But a very small percentage of them do, right? So what do? Well, you present, again, this is another reason for calling it computer-based instruction, internet-based instruction, different types of textbooks. What you're looking at is hitting different types of learners, right? Anybody who's played sports, some people need to be, you know, instructed exactly how to do it. Other people need to be led along how to do it. Other people need to practice it. Other people are these brilliant sports guys who do it, and gal, who know how to do stuff like Jordan. They can just do it. They don't need to be taught. But what we're looking at with learning styles here, theory, within the learning sciences format is that you've got to take the person where they're at, right? And then instead of just saying analogical reading, casebook, and Socratic method is sufficient, and everybody's going to learn, and if they don't, forget about them, right? Let's look to each individual person, and let's give them enough resources that's going to allow them to learn, you know, yeah.
But there, I'm not sure I can phrase this the way I want to, but I'm not sure if that's the great way to lead off. The other way to, another way to address this is to say class time and preparation for class time is only one component of what we are expecting students to come. There is text already in the form of black letter law readily available to students, both online and in the law library. Black letter law series, nutshells, whatever. And more the issue in my thinking is the faculty member from the outset saying, I'm here as one, and your time in this class is only one part of the learning process.
Well, that's exactly it. Yeah, that's exactly it. Now, does the student understand that?
Well,
Does the student understand where these resources are? Are they provided from the course syllabus? Usually not, right? So the student is led to believe that this class is going to teach me what I need to know. Unless the, you know, you get certain professors who are more progressive and
but
stuff.
there's also an argument that will be made by some who will say, if they're a self-starter and they're going to be thinking like a lawyer, they're going to be making inquiry about what is available to them and what it is they should be learning.
Yeah, and if they're a basic person who's responsible, they're going to say, I just paid you $30,000 to teach me something. All right. So basically, what you're saying, that whole argument is basically a Matazar in New York says you have basically a misrepresentation going on with law schools because you tell the student $30,000-$40,000 a year, which a lot of law schools say, and we'll teach you the law. So if you're saying they have to go out to outside sources, I'm saying yes, you're definitely right. They have to go to the outside sources because they're not going to find it within the casebook Socratic classroom. Not what they need, not what most students will need.
But I don't know of a law school that says we're going to teach you the law. They all say we're going to teach you how to be lawyers.
Let me finish here. Learning styles. Now this goes to computer. Where does the computer come in? Again, Chicago does what? Lids down is the start of every class. Lids down. We don't want you on the computer. We don't want you on Kali. Right? Because we're an old-fashioned law school and we know better.
That's not true. You're not supposed to use Kali in class. You're supposed to use it on your own.
Yeah, let me finish.
No comment.
All right? We don't want you to use your computer, to take notes, to do anything. We want the computer shut. Then they make them do it. All right? Again, this is Joanne talking about what? Learning styles. Right? And a computer should be used. All right? It's part and parcel of our society. People are wired. They walk around all day with things. All right? We do. Imagine kids. They can't think without being wired, a lot of them. So what her thing is saying here, you take the learning styles, you take the traditional classroom, and we're not saying change the traditional classroom. We're saying you're going to have to augment the traditional classroom. All right? So how are you going to do it? One way is to use the computer. Again, half the reason for this talk is to say Kali is needed, especially for those of you who are computer-based people and not law people. You really do need Kali because you're not going to get what you need in the classroom. All right? Matazar, the guy of New York, says it, the dean of New York Law School, in October, the bar conference sponsored by the ABA. He said the exact same thing. We are misrepresenting law schools. We should give a lot of the money back to these students. Why? Because it's fraud to say that we're going to teach you the law, and they don't do it. All right? So, basically, that's Matazar.
Notice, of course, he's not giving any of the money back.
You know, yeah, I know, right? He's not encouraging lawsuits, is he? But it was interesting to hear. He was the keynote there. He actually said that we are misrepresenting law school by saying, inferring, or in any way intimating that the classroom experience is going to be enough, all right, to teach law students. Both from a cognitivist theory, from a constructivist theory, from a constructionist theory. Constructionist theory is what? You build stuff. So for instance, I have my students Make essay questions. Pretend like you're the professor at the end of the semester. Make a question. That induces them to have to know what the law is so they can understand how to write an essay question. Then I have them act it out. Okay, now you have a situation where you have a murder and you have what? You have maybe a robbery, so you have some kind of assault going on, maybe a battery. I give them the different things that need to be in the essay. Right? Question. They have to write up an essay question about it, and then finally they have to act it out, and then have it filmed. Right? So that's constructionism. People learn that way. Oh my God, when I have to actually sit down and write about murder, now I have to actually write the facts, which would lead somebody to write about murder. You see? So now they're really involved in the learning process. And again, this is not going to occur in the classroom. Right? It's extra stuff you do outside of the classroom. And that's the whole point of this, is that you need this stuff. You need this stuff outside of the classroom. And again, now this is Professor Emeritus there who I studied with at Northwestern. The thrust toward computer-aided learning is an important development in education, make it possible to give more personal attention to individual students. Again, out of the hundreds of people in the classroom, right? Without which new developments in learning may be impossible to implement. Who knows when he wrote that?
1962?
87. 22 years ago. Now, I would argue we're behind the times even with computer. I hear students say, oh yeah, I got a podcast available. You mean on an MP3 I can actually listen to it? Yeah. Easy. It's called sound. Like the radio, the transistor radio you listened to 40 years ago, right? I would argue that the whole legal field as a whole, the legal education field as a whole, is way, way behind. So what I'm saying is to encourage all the geeks and all the computer-based people is you got some work to do to catch up. And you got plenty of work to do. And COGNITIVISM is providing a valuable resource by being a repository of different types of learning styles, different types of computer-based learning, again, this is just more. There are a number of people in the profession who are now asserting that we need stuff outside of the classroom. They're not embarrassed to say that you have to go outside of the classroom, like they used to be. Yes, sir?
This is not a criticism of Cali. One thing I do is I post prior year's exams on Twin and give them the whole semester to do practice exams. I won't post the answers.
Right.
But they may send to me their practice answers for critique, and I will respond. This third week in law school, they have the opportunity to start working on some practice work.
Well, that's awesome. I was talking with Susan, I forget her last name, of the National Conference of Board Examiners at a Learning Sciences Conference in San Diego last month. I said, what's the one thing that you would recommend, to change the legal profession, which would be helpful? And she said formative assessment. It's exactly what you're doing. Summative assessment is when you get in December and you take one exam and then they say, okay, that's it. You're smart, you're not, you're in the middle. That's formative assessment, what you're talking about.
So by October, you already know that the parole evidence rule is driving somebody crazy.
Right.
Because they don't understand it's a rule of discharge. You can then go into class and say, look, we're looking back at what happened before the writing was executed, and you can address the question of what they're not getting.
Right.
Way before the middle of the semester.
And you can explain it to them. And then they can see within the context of how they're going to be tested, when the parole evidence will come up, prior contemporaneous, agreements and all that, right? When did it occur? They can look at all the different aspects they need to look at, but see, now they know what context it is, that it's a discharge of performance and contract law.
But an online tutorial with prior exams is a hell of a lot of work, and I don't know how many of my colleagues will be doing it.
Well, there you go. Yeah, there you go. And then, those others would argue, like myself, why are you giving somebody $40,000 if they're not going to teach you what you need to know and give you an ability to practice? I know that when I was a kid, when I went to basketball camp, right, for a week, I learned basketball. I did, and there were people there to teach me and have me go through it again and say why it's good, and we had video at night. I would just argue that law school's really dropping the ball. And each individual person, no, you don't have time. You can't do it. You can't do 6 formative assessments with one student when you have 120 students in class, right? But that's an awesome way to do it. That was really awesome. I mean, if you're going to teach somebody, that way you get the result of how they think. And now you can say, okay, your rule, for instance, your rule statements are hazardously bad. Work on your doctrine. your analysis is good, but you know your structure is all messed up. You did parole evidence, before you did what area of law? What is it? Common law or UCC? You didn't even describe that, but you got to get basics on this thing, and that's an awesome learning experience.
And it's so much better to have them submit what they're analyzing in writing instead of that. Conferences are great, but their limitations are what you can accomplish things.
Yeah, and the thing with the learning sciences is people take in information in different ways, but you need that formative assessment because you're going to have the same product. You can't write a flow chart and say this is my answer to this particular question. Lawyers have to write, and they have to think like an attorney, right? Yeah. Questions? Yeah.
Mine's more just a sort of, I've sat there and listened to this. I don't think my law school experience was too dissimilar from your own
Right.
in terms of its own frustration. But I sort of, at the end of this, I don't see what you're offering is all that much different in terms of tons of outside class time spent on all these hands-on learning things. And that's basically what you had to do in law school. You got that fringe, but then you had to go meet your study group. You had to go read the black letter law. It still took all that time outside of class.
And who led those classes?
You led them with your study
Well, there you go.
And what
So why don't you just hire your study group at $40,000 a year and do that?
So but
That's the whole idea.
There's more. No, because there's more. If you're really going to be a lawyer, you have to understand the fringes, and you have to be able to argue the fringes because the law is constantly changing. So I could sit there and learn the black letter law, but I couldn't be a good lawyer necessarily unless I understood how to make the nuances in the arguments that might be needed in my client's defense. So, and I think that's what the faculty members are stressing in their classes, but, I'm not going to defend it that much because honestly, when it comes to distance education and I'm trying to convince my faculty to do this, they think I'm crazy because how can they teach those nuances? And I'm trying to figure out how I could, teach those nuances.
Formative assessment, just like he was talking about.
Yeah, there's different ways.
That's an awesome way to do it. Yeah.
I agree that there's room for improvement in legal education. I think all of us would. I think it's easy to bash it too, because I'll admit that at every institution I've been at, there have been some teachers that are better than others, some far better than others. I don't think any of them come close to committing fraud on students, even the students that don't get the grades that they might be able to get. And I do think some of what you're suggesting is there, because in addition to the cases, addition to statutory material, other materials, we have treatises, we have the workbooks, as has been pointed out. The classes have never been the whole thing. Even my mathematics class, even undergraduate class, it was never the whole thing. There was homework to do. There was meeting with your student. There was sitting down with your parents. There was sitting down with other people who knew the math better than you did, right? And your older brother or sister or something. So that's always been there. Now, that being said, I think we can do a lot more with technology. And when I hear the argument in my own institute, closed laptop thing, I'm like, screw that. I've got a couple of professors. There's a student, they can have their laptops open. I can guarantee you they're not shopping for shoes. And it's because that teacher holds their attention.
Exactly.
You're exactly right. And if I have something and I have the passion and I want to bring it to you, there is no reason that you should be shopping for shoes in my classroom. And that's what we're missing. But I don't, to go overboard and call it fraud or call it that.
Well, that's what matters are represented
I
in that.
understand.
Given the amount of money that people are paying in this economy. Now, the whole idea, I think what we're trying to get across is that how can more students, so this is the mastery learning concept, right? Why do we let some students just be down here? Tell them about all the resources they maybe can use. Form study groups with students. Have the TAs from upper levels come down and teach. There's a whole plethora of things that can be done very easily and very cost effectively, Kali being one. And let the students know about these things so that more students can reach a mastery level, an expert level of reasoning.
But some of the pressure that comes is from the bar, from the practicing bar, because they don't want to get into the mentoring process that has, for 150 years, been part of the process. We don't have the medical education process. We don't come out with a degree, pass the bar, then go practice for 3 years before you become a doctor.
Right.
We don't have that. Oh, that's too expensive, we can't do that. And yet, the practicing bar said, well, wait a minute, what, I'm tired of doing it. We're teaching writing, we're teaching grammar, we're teaching things, and the curriculum, you can't go past the 3 years, because that's too expensive, you gotta contain it here, and yet, okay, we want some more practicum, we want some more things, so it's somewhere, something's gonna give. And that's, I just bring that up.
We're right on time. We got one more question. Yeah.
I think that your points about the students' needs are very valid, but I think when they're paying such a large amount of money to go to law school, and they want a lot handed to them, one of the most important things to hand to them is to tell them how to get the grades, tell them what a good analysis is, and how to write it, and those kinds of things. And as background information in your teaching materials, perhaps, if you don't have time to use classroom time to do it. But the rubric is one of the most important things. They find it insanely frustrating to go into a school and find out that there is no right answer. And they're desperate for the grades, and there is no right answer, and they're lost. So it's really, really important to put the rubric in somewhere.
And teach IRAC and all that stuff along. Yeah. Good. Well, thank you, everybody. I don't want to keep you over. Appreciate it.